Under that lens, the evidence already submitted with the notice of removal is sufficient, then the court should be ordered to take jurisdiction of the case and proceed forward.
As we've described in Ibarra, right? Pick up there.
Right. As you've described in Ibarra, you have declaratory or summary judgment type evidence. I understand from respondents' brief that they take issue with one of the declarations submitted in support of removal. But it was a removal. So if additional evidence is required and they're challenging it, at least here, then we should be provided an opportunity to present that evidence.
Right. So that's what forgive me. I'm sorry.
No, go ahead.
I'm just trying to get to following up on Judge Callahan's point. It was sua sponte. So that this back and forth hasn't happened yet.
It hasn't happened.
Okay.
And I think perhaps some direction from this court would be useful as to what would likely be expected or should be evaluated and under what lens.
Well, what should happen? Let's go back to when you filed your notice of removal, and the district court evaluated your notice of removal, and sua sponte entered the remand. What should district courts do in these cases? Not so much this case, but what should district courts do in these cases? Because I don't think, whether it be this circuit or other circuits, we want to see all of a sudden hearings on every notice of removal to determine whether or not the jurisdictional amounts have been met. If you just limited that to CAFA, that would be enough additional work. So what should they do?
So I don't presume to know what an Article III judge should do, Your Honor. I can tell you what I have seen.
What do you suggest we should do?
I would suggest that they issue orders to show cause regarding jurisdiction. I've seen many
in
other
all
courts.
cases?
No, only in a case where the court itself has a question about whether or not jurisdiction exists. If the court has no question and it's not challenged by the non-removing party, well, then there's jurisdiction unless it's later proved that that's based on some false assumption. Here,
well, isn't there there's certain assumptions that at the pleading stage the case law would seem to say that you can rely on, and that there could be challenges later as to that, but it seems that the district court appears to maybe have imposed on Marriott the burden of proving its assumptions were correct, and that it in fact violated the law and did so as frequently as assumed in the estimate of the amount in controversy, and that Ibarra allows for a chain of reasoning that includes assumptions, so that the district court, the argument, I guess what I'm seeing is it seems like sua sponte didn't allow for those assumptions, the chain of reasoning of the assumptions, and that's just at the pleading stage.
I would agree with that, and I think that really does go to the heart of the issue of whether there is a requisite amount of controversy, again, at the time of removal. Here, the bulk of the amount in controversy comes from off-the-clock work and rest break claims. Those are claims that necessarily don't have records for an employer to produce.
Yeah, but for starters, we can't tell how many of these people work full-time as opposed to part-time. I mean, we just didn't get there yet.
We didn't get there yet, and certainly my client would be happy, willing, and able to submit additional information to show that point. But once they do that, there still needs to be, to Judge Callahan's point, the assumption of a violation rate.
We have said in Ibarra that there's some assumptions are going to be permissible for sure.
Right.
But just as you haven't had an opportunity to really support your notice, there's been no opportunity from the other side to take shots at it. So it feels to me that this conversation feels premature. I just want to give you a chance
I would
to
agree with
respond.
that up until the point, except that there is a time frame within which to file a motion to remand. One was not filed. So there was a time frame for taking a shot at it. I'm not suggesting that if we were to go back and submit additional evidence, that evidence couldn't be contested by respondent in this case. But they did already have that opportunity. They didn't take it.
Do you agree that what just because we talk about and DART talks about, DART Cherokee talks about if the opposing party or the court takes issue. I think it uses the word challenges.
Challenges. And in this case, I think it's fair to characterize the district court's sua sponte order as a challenge to the removal, but a challenge which we had no opportunity to respond to.
Okay.
With